So two kind of parts to that. The overtime thing would be known as a repetitive trauma claim. So a data entry person, someone who's typing all day, develops carpal tunnel syndrome over years of doing that job, could be an accident, right? It could end up being a compensable injury that workers' compensation would have to pay for under a repetitive trauma theory. Those are more difficult to prove, but definitely not impossible. It depends a lot on the doctors. It depends on the job duties, and so those cases are certainly cases that we can pursue. But the part of that case, or the second part of that question, being the exposure to arsenic. So now you're getting into more of an exposure theory, occupational disease type theory, which makes it significantly harder, not impossible, but significantly harder. Just standard exposure cases like there's mold in my building, nearly, if not impossible, to prove under the current statute in Florida. But occupational disease, things like hearing loss, exposure to certain chemicals can be a compensable workers' compensation case, but they are very fact specific as well. One of the things like exposure to, sometimes you get chemical burns, you were exposed to a chemical. That now you have a physical injury to go along with some of these more, these symptoms that they would classify as more flu-like or just standard, something like shortness of breath, right? People have shortness of breath. How do you relate that to exposure at work? It becomes extremely difficult and very, very fact specific. Generally speaking, those cases are not very winnable cases. If you have lead poisoning and you work in an ammunition factory, that might be a little bit easier to tie to your employer. But it's going to come down to who your employer is, what the situation is. But they're difficult. They're difficult, not impossible. Cora, what do you think?
Extremely difficult. And the problem with occupational exposure cases is that the standard in the law is higher. So what we have to prove as attorneys in those cases is different than what we have to prove in a case involving a one-time event, a physical injury, an actual one-time accident. So for those occupational disease cases, we have to bring in medical evidence establishing that what our clients are suffering from is something caused by that environment, and that there is sufficient exposure to whatever it is that is causing them the medical issues, that there has been sufficient duration for them to develop that disease. And so it becomes extremely difficult to prove simply because it has to be based upon epidemiological studies, and it has to be based upon medical evidence saying that that particular exposure to that particular individual is what is causing their medical condition to arise.